Okay, let's jump right into a fascinating legal mystery from 1999. The South African Constitutional Court had to solve a high-stakes math problem literally days before an election. Welcome to The Explainer. Today, we're looking at a classic showdown in constitutional law, a true heavyweight bout between national legislation and provincial independence. The case is the Premier of the Province of the Western Cape versus the Electoral Commission, and the whole shebang came down to one deceptively simple question. Exactly how many seats should there be in the Western Cape Provincial Parliament?
We're going to unpack this courtroom drama by looking at the initial battle for seats, clearing a quick jurisdiction hurdle, diving into the clashing laws, examining the counter-arguments about equality, and finally getting to the ultimate verdict.
Starting off with Section 1, the battle for seats, South Africa's 1999 election crisis. Our explainer begins on the absolute eve of South Africa's second democratic election, where a massive crisis is brewing over the size of the Western Cape legislature. It's a hugely critical moment in the country's history. This was the very first election managed entirely under the final 1996 Constitution. That means the actual mechanics of this new democracy were being heavily stress-tested in real time.
So the Electoral Commission, who was tasked with organizing this massive nationwide event, made a determination on March 17th. They were just executing their duty as they understood it under national law. They used a strict mathematical formula prescribed by the National Electoral Act, which was one representative per 100,000 inhabitants. Based on a population figure of nearly 4 million people, this formula dictated that the Western Cape legislature would have exactly 39 seats.
But the Western Cape provincial government flat out rejected that number. They pointed directly to Section 13 of their own custom-built 1998 provincial constitution. And what did Section 13 say? It demanded a total of exactly 42 elected members, not 39. So you have this direct, glaring contradiction right on the doorstep of a national election.
And the sheer panic of the situation is just incredible. The commission made its call in March. Letters of objection were fired off in April, but the urgent court application wasn't even filed until May 20th. That left the Constitutional Court mere days to hear the arguments, interpret the Constitution, and issue an order by May 26th, all before voters actually went to the polls on June 2nd. The potential for absolute electoral chaos was, frankly, sky high.
Moving to Section 2, a question of jurisdiction. Can the Constitutional Court hear this? Because before they could even look at the numbers, the court had to figure out if they were legally allowed to hear this 11th hour case directly. The applicants, meaning the Western Cape Premier and Speaker, claimed the Constitutional Court had exclusive jurisdiction. Why? Well, the Constitution says the court handles disputes between organs of state in the national or provincial sphere. Now, normally an organ of state is pretty easy to spot. Think of a standard government department. But this gets tricky. As the court noted, the Electoral Commission is fiercely independent. It doesn't neatly fit into the category of a standard national or provincial government department. If the commission isn't technically an organ of state in those specific spheres, does the court even have the right to be the first and final judge on this?
The crucial point here is that while exclusive jurisdiction was highly debatable, the court brilliantly sidestepped the red tape. They used their rule allowing direct access when it serves the interests of justice. Since the issue was a single, crisp point of constitutional interpretation, the parties were ready, and the June 2nd election was literally staring them down. The court granted direct access to prevent total disruption.
Now for Section 3, the constitutional clash, national law versus provincial law. Let's see how this jurisdictional hurdle gives way to a heavyweight match between national legislation and a provincial constitution. This is where the legal gears really start turning.
We have a direct collision on our hands. The National Electoral Act's strict mathematical formula is on one side, mandating 39 seats, going right up against the province's custom-built constitution on the other, mandating 42. So what happens? Who wins when laws collide?
The Western Cape had a really strong shield here. They argued that Section 143 of the National Constitution explicitly gives provinces the right to design their own unique legislative structures and procedures. As long as they adhere to foundational constitutional values, a province is allowed to be different. And part of being different, they argued, was choosing to have a 42-seat parliament.
But the Electoral Commission fired back with Section 147. This section states that if there's a conflict between national legislation and a provincial constitution regarding a matter where national legislation is specifically required, the national law must prevail. Since the national constitution says provincial seat numbers must be determined in terms of a formula prescribed by national legislation, the Commission argued their 39-seat formula legally overwrites the province's 42-seat rule.
Bringing us to Section 4, the equality argument, the Electoral Commission's defense. You see, the Commission didn't just rely on technicalities. They brought forward some really heavy constitutional arguments regarding fairness to defend their 39-seat calculation.
They argued that if you give the Western Cape 42 seats instead of the 39 they mathematically deserve based on population, you're essentially giving their voters unequal, disproportionate power. They claimed it would make the Western Cape out of step with the rest of the Republic, violating the fundamental right to free and fair elections. And, as a kicker, they pointed out that adding 3 extra politicians places an unfair extra financial burden on the state taxpayer.
The court systematically dismantled these fears, and their logic here is fascinating. First off, South Africa uses proportional representation, meaning seats are assigned based on the total percentage of votes a party gets overall, rather than a winner-takes-all district system. Because of this, the fundamental strength of an individual's vote isn't magically increased just because there are 3 more chairs in the room. Second, adding seats locally doesn't give a province more power nationally. In the National Council of Provinces, which is the upper house of parliament that represents provincial interests nationally, representation is strictly capped at 10 members per province, regardless of population or local legislature size. Finally, the extra financial cost wasn't forced on anyone. The provincial constitution was democratically passed by a 2/3 majority in the Western Cape. They consciously accepted the bill for those 42 seats.
Which takes us to Section 5, the final judgment, resolving the legal mystery. With the counter-arguments thoroughly debunked, Justice Goro and the unanimous court had to solve the core puzzle of the clashing laws.
The judge introduced a brilliant metaphorical framework to solve this. She explained that the national laws regarding seat formulas aren't unyielding commands for everyone. Instead, they're simply default provisions. Think of it exactly like a default setting on your smartphone. If you don't change anything, the default applies. It just provides a framework for provinces that haven't written their own constitution. Because the Western Cape had gone through the effort of legitimately writing its own constitution under Section 143, they essentially went into the settings and turned off the national defaults. The court ruled that once a province determines its own legislative structure, national legislation cannot alter it. Therefore, that scary conflict we looked at earlier, it didn't actually exist. There was literally no conflict for Section 147 to resolve because the national default rule simply did not apply to a province with its own valid constitution.
So, the mystery is solved. The Western Cape was absolutely legally entitled to its 42 seats. The mathematical formula from the Electoral Act had no authority over a province that had already defined its own structure.
Justice Mokhokoro's decisive ruling was crystal clear. She stated, the determination made by the first respondent that the Western Cape Provincial Parliament will have 39 seats is invalid. The court unanimously declared that the Electoral Commission's math was out. The ruling protected the province's constitutional independence and ensured that when voters went to the polls just a few days later, they were voting to fill 42 legally protected seats.
This case leaves us with a thrilling question about the balance of power in government. It shows us that constitutional law isn't just rigid text. It's a dynamic system with built-in flexibility and default settings. If national laws are sometimes just waiting to be customized, what other default rules in our democracy are waiting to be overridden by local action? I really hope this explainer has sparked your curiosity to look a little closer at the actual mechanics of the laws that govern us. Thanks for joining me, and keep questioning how your world is structured.